We are on the record.
Good morning. This is the matter of Fisher versus Crow and Archer and all other occupants. Case numbers 25LT25667. I'll ask the parties to put their appearances on the record. We'll start with the plaintiffs.
Good morning, Judge. Harry Ainsworth, AINSWORTH 904618, attorney for Mr. Fisher, the plaintiff, and he's here.
Good morning. And you are?
Good morning. My name is Garrett Archer. I'm a defendant, and Ashley Crow, unfortunately, is not here today. She had a surgery with her grandma. She's the only caregiver that can step in, and we weren't able to schedule it out for some reason.
Okay. Thank you. We're set for a jury trial. I know that there are several motions that we have to address before the jury trial, and then even if we get by the motions, there are the preliminary matters that we'll have to discuss as to like how we'll do the jury trial, a neutral statement of the case, and things like that. But we'll get there when we get there. I have several motions that I have in front of me. I don't know if there's a particular order the parties feel would be most efficient. It seems like there are two motions that are similar. One is a motion to reset and a motion to abate. And then we also have a motion for reasonable accommodation as well as a motion to disqualify Mr. Ainsworth. Before we actually get into the merits of the motion, am I missing anything that we need to discuss aside from those four?
Is the motion to abate, is that the same as the motion to vacate the order resetting?
I think that, no, the vacating order resetting was filed yesterday, I think?
Yes.
Yes, and that's based on Ms. Crow's unavailability, and so that's the first motion. The second motion to abate is because you have the pending criminal matter.
Yes.
And then so it's a different topics, and then the motion for reasonable accommodation, and as well as motion to disqualify counsel. So those are the motions that I see, or this court sees, as motions that should be addressed before we address the jury trial. I just want to figure out if I'm missing anything before we start going into the merits. Okay, so the first motion is motion to reset, and this is Mr. Archer and Ms. Crow. She's not present, but your motion to reset based on the unavailability of Ms. Crow. So go ahead and make the record as to what you want the court to know.
Yes, so that was essentially just today was the only day that we had unavailability, and we had said as much in several hearings under oath and attempted to confer upon hearing that the first trial was going to be reset, and by whatever circumstance it ended up being set for precisely this day, and in spite of our attempts to try to remedy that, it was not able to be accomplished, and so yeah, the reset or motion to vacate, as it were, I thought was a good way to go, but totally prepared to just request that 2-day continuance. Like I said, complete availability any other day, and I'm unable to have served my subpoenas that I wanted to serve, which kind of gets at some pretty crucial evidence for us, because we were up in the air about what the day was going to be for it. So it would be very helpful in order to allow us to plead our case, and indeed my co-defendant is currently the only person who can actually go to the property because of other circumstances. So it would be great if we could have her as a witness and a party. So yeah, I was asking that we are able to do one of those things. That would be probably my most crucial thing that I would be asking today at this point.
And before I ask Mr. Ainsworth to respond, I just want the parties to know that I've checked with calendaring. There is not a judge available today or tomorrow if we bump it out. It would be outside of the 2 days, which means it triggers the payment of rent, because the statute says we can continue it for 2 days if based on defense motion, but if so, then they would have to you would have to pay rent in the court.
Right. So then I guess the question becomes the interpretability of the ledger has been incredibly up in the air. I haven't actually had a conversation with the landlord since 15 days after we moved in, and that's when all contact was cut off completely, in spite of many attempts in multiple directions at solving that. So whatever the amount of rent would be that would need to go into escrow would be of interest, but fundamentally, in the conference, for example, in his motion asking for the trial reset, he states that he encountered objections and filed a copy of them, but I didn't see any copy of the objections, and indeed, I thought we were very straightforward and in good faith, upon his scheduling issue, being very prompt about what days worked for us, which was every other day. So in that regard, it would be difficult for us to put up a large amount of money right now because we have to pay for 2 homes at the moment. But that would be the hope. I was hoping for Friday so that I could ask for that continuance. And plaintiff has had a few continuances. I know the rules apply differently to defendant, but.
Okay. Mr. Ainsworth, do you want to be heard on this motion, please?
So, Mr. Archer states that he, in this matter, made several statements under oath, but that's not possible because we've had no hearings that involved any oath taking at all. So that's just not true. Originally, Mr. Archer said when I had sent an email to confer on the set-over, he said that Ms. Crow had a conflict for the following week. That was the week of, so that was starting, that message came on 11/28. That would be the week that contained the 4th, last week. When the court set the hearing for the 10th, suddenly that became the day Grandma needed surgery. Whether it's true or not, I don't know. We haven't seen any documentation to back up the claim that either Ms. Crow is necessary nor that her grandmother is in fact scheduled for surgery. What we do know is that these parties, and Mr. Archer in particular, have filed a slew of motions doing anything they can to delay trial. I think this is just one more gambit at delaying trial on this matter. The rent is $1,200 a month. The statute at a bare minimum would require, this case was filed shortly after the 8th. It was filed on I'm guessing it was filed the 9th or the 10th. I don't have that right in front of me. But we would ask that November and December be paid into court, but at a minimum, December certainly. I sent numerous emails to Mr. Archer and Ms. Crow in the last couple of days saying, if you ask for a set-over, it's likely that it's not going to be for 1 or 2 days, and you will be required to pay rent into court. And I ask you to bring hard funds into court, because Mr. Archer's reliability in this matter is varied, and a personal check is not going to do it. It should not be security. He can come with cash or a cashier's check that's valid and pay that in. So as late as last night, we had an exchange, and he was saying, well, it's only going to be 2 days. And I said, well, I don't think they start jury trials on Friday. That's typical, not done in most jurisdictions. And it's doubtful that there'll be judge available the following day, so be prepared to bring in your rent in cash or check. So the fact that he doesn't have it, that isn't our problem. It's Mr. Archer's problem. And so we would oppose this sort of, and in addition, there's no evidence in the file at all that, quite frankly, there's no evidence that there is a grandma, that grandma needs surgery, that the surgery is today, and that Ms. Crow is somehow necessary to do something. There is evidence in the file, or in another file, I believe a restraining order that was filed. Oh, and just to inform the court, there is a pending restraining order. It was just served against Mr. Fisher and Ms. Crow in this matter. So if she appears, just to keep the court informed. But in that, Ms. Crow bemoaned the fact that her car had been towed and she had no transportation. So it leaves a question as to what kind of transportation she's performing for grandma. She could be using grandma's car. I don't know. But nothing in the record tells us what it is. I think it should be denied.
And I'm going, before I ask for a response, I think maybe it's best, just because I don't want to put Mr. Ainsworth in a position that may not be ideal for him, is there's a motion to disqualify counsel. Maybe we need to address that first, because I don't want you to do, at least we flushed that out, so because I don't want you to do anything in that would impact or maybe influenced by the rules of professional conduct going forward.
I would be happy to deal with that first.
Okay, so why don't we, are you ready to go on that motion?
Could I take a couple of minutes and address just a couple of things as part of the rebuttal before we move forward, just so I can
I would prefer to do the disqualification of counsel first, because I don't want to have Mr. Ainsworth continuing. If I find that there's a conflict, I don't want the conflict to be continuing and propounded or continuing if we need to resolve it.
Could I take maybe 60 or 80 seconds to reinforce what I had? That way we can come back to it. It would help my...
Yeah, just take, go ahead and take
Probably
your
won't
notes.
even do that long.
Yeah, write down your notes for the rebuttal, but
Thank you.
Yes.
I appreciate it.
Okay, whenever you're ready.
So would I speak first on
Yes,
that?
yes, it's your motion.
Okay. So for the motion to disqualify, basically it stems from the fact that this is the same counsel that I was consulting with in my previous landlord-tenant situation, which is still open, and it would seem, at least to us, by preponderance of everything that we have, that there was tortious interference on behalf of that prior landlord with Mr. Fisher, and I have information recently, as of at this point, like 3 weeks ago, that they have continued to interact with one another. And these two cases are very, very similar. They both start with accommodations requests that were blatantly ignored, not participated with, and met with notices to quit. And his response to my motion, stated that I was purporting my disability to be the kind of confidential information, and that it wasn't confidential at all because it's a kind of a public thing because I'd filed bully complaints and these sorts of things. But more so, it's like my kind of entire, ways of thinking, and certainly more than a cursory knowledge, at least to the point of implicit bias, perhaps unwitting bias. He's going to have, and again, the exhibits that I attach to that motion are records of our conversation. And indeed, with the the need for the reset that we had just spoke about, leading to, after we spoke not on the record, or not under oath, but on the record, about the one day that we couldn't come back. It does seem like every single thing that is being done kind of has a bit further leverage being applied, and I do think it comes from a place of unethical knowledge, of our exact situation. Even if the previous landlord is not conspiring with Mr. Fisher, the facts of these cases are incredibly similar. This is the second action that seeks to evict us, but defendants allege that these all started with, lawfully protected accommodations requests, and they have ballooned out from there into, lots of different things, and unsafe environment. But, I raised the issue very quickly as soon as I found out, and Mr. Ainsworth claims he did not remember speaking to me, but it was fairly rigorous, and just to say, it was appreciated at the time, but now it's I don't know, it seems unethical, but I've been confused about where ethics are really kind of concrete foundational things. I've read the professional rules, but beyond that, I don't have, obviously, a super professional understanding of where he would be expected to draw the line for himself, or where interaction would be asked from the court, or would be coming from, like, the court to him to inform him how to do it. That's just beyond the scope of what I truly understand, but I certainly feel he has weapons with which he can attack me specifically because of the relationship we had, however somewhat brief.
You mentioned that there were emails. I have your declaration, but I do not have any attachments that have emails or anything.
It is possible that
You should.
Okay, let me make sure. I have the motion and the declaration, but it may be I may be looking at.
In my file, Judge, they're attached. Some of them at least appear attached to the declaration. Mr. Archer, you might want to supply the court with your copy of the declaration.
I should have.
I don't want to be accused of having shorted.
Give me a second. I want to see if I can find. I'm going into a different program. Give me a second. I only see a declaration file, but I do not have. Do you see it?
Your Honor, I think I see it on the declaration from November 21st.
Mm-hmm.
But I don't see attachments with it.
I see 18 pages. I flagged it green.
It may have been amended.
Okay, because me see, maybe I gotta look in the documents tab. Oh. Okay, I see it now. Give me a second, please. I didn't see these emails before, so I want to review them just to see the extent.
They are hard to find. They're not attached to my copy.
Okay. Okay. Anything else, Mr. Archer, before I turn it over to counsel?
Yes, I would just kind of briefly touch on his points raised in his response. As far as questioning my claims of disability, I do believe I have provided plaintiff with substantial proof of that with doctor's notes, and plaintiff's previous attorney agreed to pay the statutory damage for retaliation for failing to accommodate the disability. So it's at least known to plaintiff, if not plaintiff's new counsel, Mr. Ainsworth. But I felt like I should certainly speak to that at the risk of speaking to things in the past. I've found if I don't speak to certain things that appear like they may be obvious, that I may be doing a disservice to my case. So, but yeah, no, I think that's pretty much what needed to be said.
Mr. Ainsworth.
So I acknowledge that those were an email exchange between Mr. Archer and I. Occurred around the first FED. I didn't choose to represent him in the matter, but I did advise him a little bit. Not thoroughly, but I did a cursory look over at his case. That would have disqualified me from representing the landlord in that case. But this case is entirely different. The only similarity is it happens to be the same area of law, and that Mr. Archer is one of the parties. Other than that, the previous case involved a landlord that chose to give a landlord's notice because they were going to move in a family member into the apartment to have Mr. Archer be removed. Mr. Archer raised a number of defenses to that case. And if we look at the case C.O. Holmes, C.O. Holmes case, the Supreme Court ruled in FEDs that the case is the notice. The notice is the primary mechanism for an FED case. So that case had a very different kind of notice between different parties. The defenses that were raised by Mr. Archer were all fact specific. Whether that landlord canceled garbage service, whether that landlord failed to reasonably accommodate his request for garbage service, whether that landlord reasonably accommodated others of his request, whether she discriminated against him in other ways. Those were all whether she retaliated against him for complaints that had to have been made about that tenancy. All of those are very individual to that case. This case involves a 24-hour notice. It's pretty straightforward. Mr. Archer shot out a camera on the property and damaged the building that the camera sat on and destroyed the camera. The issues in this case are going to be whether or not his act was outrageous or did substantial damage to the property. It's a very simple case, very unlike the first case. Honestly, looking at his pleadings, I'm not sure what affirmative defenses he's raised. It seems like retaliation is one of them. I can definitely kind of identify that. We will deal with the retaliation claim, but that retaliation has to be Mr. Fisher retaliated against Mr. Garrett, not that Ms. Pletcher did. So again, fact-dependent and individualized to this case. There's no conflict that travels with the person as if it's a different matter. I mean, for business reasons, people often don't like to take cases against former clients, but that's a business question, not a ethics question. I haven't seen anything to back up the claims for disability. My client, while we were sitting here, told me he hasn't seen any doctor's notes regarding a disability. I'm not saying that Mr. Archer doesn't have some sort of disability. I'm just saying he hasn't proven one or shown solid evidence of one. There's an allegation of judge shopping, which I find odd. In one way, because it's predicated on Mr. Archer's belief that Judge Norby somehow favored him, and thus he should be allowed to have a judge who showed him favor. If it had been apparent to us that she favored him, we would just have disqualified her. But the fact is, I did represent Judge Norby on an unrelated personal matter, and as such, she ought not hear a case and recused herself properly. That information until now was not generally known or public, not for any nefarious reasons, just out of discretion. So Mr. Smith, the prior attorney who brought me on, he had no idea, and Mr. Fisher certainly would have no idea. So there was no judge shopping. And then as far as the other stuff, quite frankly, I don't understand it. I don't know what dark pattern litigation is. Mr. Archer tried to explain it to me, but said it's an incomprehensible concept involving searching the internet for secret clues that are hidden in things. Honestly, I'm the ultimate boomer in technology. You could put a gun to my head and I couldn't search the internet for clues. There's no dark pattern litigation going on. I ought not be disqualified in this matter.
Anything else, Mr. Crow?
What was that?
Anything else?
Yes,
on this issue?
I do have a rebuttal. So just we're kind of working backwards, I suppose. Mr. Ainsworth denies understanding the definition of dark patterns, which is not incredibly material here, but he feels he has sufficient knowledge to claim he is not participating in that. This is a term that has gained in prominence recently, especially as it pertains to people with disabilities like mine, and the difficulties that it introduces, where you kind of see by outcomes being incredibly not helpful. And thinking out loud here, I don't see anywhere in my motion that I had claimed that Judge Norby was favorable to us. She had just received my request for accommodation and seemed to understand the nature of my disability. which is at times difficult to explain, as well as she was aware that the previous case was dismissed at the time that plaintiff did not want to comply with my motion to compel production of evidence, specifically evidence from his security cameras, which are certainly illegal. It is now certain, based upon exhibits that are active in this case. It's a motion tracking, facial recognition, audio recording camera that was placed after we moved in and after they stopped talking to us, and fundamentally watches our every move, and had become an enabling factor to the point that we were actually in danger when we were seen on camera. That gunfire rang out twice. That has been confirmed by police. It was stated that perhaps there was shooting of squirrels that was happening at this time, and it wasn't gunfire in a menacing direction towards us, but that's certainly not the message that we got. And sorry, I realized that is a bit off topic. I will finish this here. Same area of law, indeed. I apologize. At the beginning of what Mr. Ainsworth said, he seemed to be describing that the person who is charged with retaliation is different. The landlord is indeed different, but I don't think that has any actionable possible frame of reference for how his representation with me in the past would put me in a bad position now, because the past conference and information that he got from me is really to do with my response to the retaliation, to the discrimination, the kind of the understanding of my disability is important, but more so the understanding of my legal strategies and my general feelings and approaches. And again, he kept talking about the necessary difference between Mr. Fisher and my previous landlord, Mrs. Pletcher, but the question is not whether he represented Ms. Pletcher, it's that he had represented me in some fashion. And certainly I thought that was beyond the threshold for which he should personally consider ethically responding to it. Yes, I believe they are substantially, incredibly similar, and we do think at this time that for some reason our previous landlord violated her court order and advised our current landlord to do the same thing, ignore our asthma accommodation request, which is the first one, because there's no windows or doors in the place and the air stopped working, so I couldn't breathe. And that was never responded to. But I think they're substantially similar. I apologize for rambling.
I want to make sure you have a full opportunity to share what you want to share.
Yeah, I appreciate it. I'm starting to feel decent that I have kind of rounded through the things I thought about wanting to say in response to what he was saying. I would be interested to hear what possible circumstance could lead to a more substantially related thing. Other than obviously me, retaining him and having paid him and been fully represented in the past. But as I look through the emails, there's plenty of information there, I think, that would make taking someone like me out of the equation for the court thing easier. And also, both of those cases initially failed to prevail in this action, this is the second action in an attempt to evict. Generally, I would assert that that's because, it's hard to evict with like lots of bad faith, and they're not as cut and dry as, well, this one was retaliation, this one was because of a dispute over garbage. Like generally, it was communication breakdown stemming from a lack of landlord duties and duties under the FHA and ADA. Those are pretty core to both things, I think. And I've felt the effects of Mr. Ainsworth's ability to, I think, kind of target me specifically. And I'm saying that confident to a point that, I am trying to also examine my own failings and biases. And, obviously I'm not going to be very good at this compared to a professional. I do think there's certainly a little something extra there, based upon, our previous interactions with each other. So yes, I would ask that, I think, to enable us to have a not prejudiced attempt at fairly defending ourselves. To speak to the Judge Norby thing, as far as the judge shopping thing, we, in a previous hearing, had witnessed, I believe, Mr. Ainsworth representing a different client who was in front of Judge Norby, and the same conversation that played out with the recusal played out in this previous hearing, which Mr. Fisher would have been a party to. So that was the only reason we alleged that it was possible that there was judge shopping, because as it ended up being, Judge Norby actually having some stated understanding of my disability, that's a very contradictory approach than that of my landlord. So it seemed logical to us that perhaps that was the impetus that led there, based upon their desire to, roll the dice again on, a judge that was not fairly understanding of my somewhat difficult time explaining things. And, certainly I think there's a lot of room for error in what I'm trying to do here. So it certainly wasn't because I felt that we were favored by Judge Norby. Yes, probably not a very good conclusion, but I did think I said things.
What are you requesting, if I agree with you and remove Mr. Ainsworth, are you requesting we still proceed to trial with Mr. Fisher representing himself?
No, I seriously doubt that would be the case. In the previous action that was dismissed on December 6th by plaintiff, just prior to that, they got a continuance to get new counsel. That's certainly something that's been done several times on their behalf. Functionally, in order to make it like, a good faith, kind of well-rounded thing, I would say it absolutely could be up to them what would happen next. Like literally any amount of time, not to get too far back on the continuance thing, but much better prepared on any date but today. And certainly I think we could get a fair shake if there wasn't that conflict. So.
Okay. I'm looking at RPC 1.9, and it says, at least subsection A is, a lawyer who has formally represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless each affected client gives informed consent confirmed in writing. So the court believes that even though there was not a formal representation, there was an attorney-client relationship. At least under A, it requires consent in writing, which I do not believe we have in this file.
Could I say?
Give me a second.
Okay, sorry.
Under D, it defines what substantially related means, and under subsection 2, there is a substantially related matters are matters where there is a substantial risk that confidential factual information, as would normally have been obtained in the prior representation of the former client, would materially advance the current client's position in a subsequent matter. I don't have enough to get that hurdle so I understand this court agrees with Mr. Ainsworth that there's not enough confidential information that would trigger a requirement of informed consent. Having said that, the request, at least in front of this court, to have Mr. Ainsworth disqualified is denied. Out of an abundance of caution, I would probably ask Mr. Ainsworth to reach out to the bar's ethics hotline just to see if they have any advice for him as to whether he should continue to participate in this matter. Which leads me to, and I think this is actually the one that I think will move the needle more so than the first motion, is the motion to abate based on the Fifth Amendment rights. And just to be consistent, just to let you know where this court has routinely ruled, not in the landlord-tenant matter, but in protective orders where the parties are in front of the court or they have a protective order, or the pending case is a civil protective order, but the protective order arose out of an event in which one of the parties is subject to criminal allegations, and this court-wide have routinely continued the civil matter while the criminal case is pending, because any testimony from the person subject to the criminal matter is they may be providing information that could be used against them. If it's sworn testimony, it could be used against them in the criminal proceeding, and that would be against their Fifth Amendment right to self-incrimination. So that is typically what would happen in this case, and since Mr. Crow has raised it, he has a fundamental Fifth Amendment right to not incriminate himself and not to, I'm sorry, Mr. Archer, fundamental Fifth Amendment right not to incriminate himself. So Mr. Ainsworth, if you want to be heard, I'm happy to hear about it, but this court, in similar circumstances, would routinely grant the continuance just because the criminal matter. Now, the question becomes what happens with the property, what happens to rent, because it's not quite a continuance based on defense continuance just because they're not ready. It's a different kind of continuance. So, Mr. Ainsworth.
So the cases, the defendant cited the Keating case, which is federal law and isn't binding, but actually sets forward a set of nice criteria that seem logical to apply. And when the Oregon Supreme Court has looked at this, they have not said that the matters should all be stayed as a matter of course. What they did say is that, as in a criminal matter, in a civil matter, when a party invokes the Fifth Amendment, that the jury or the finder of fact would be instructed that no negative inference can be drawn. So from that, we know that staying cases universally is not required. And so what we have to do is we have to balance what's going on. And in this case, what we have is Mr. Fisher and his wife live next door. They live about 800 feet from where Mr. Archer lives and Ms. Crow live. So what we have is we have an instance where a tenant, in order to resolve his difficulty with the landlord, used a weapon to destroy personal property in a fairly reckless manner. He had no knowledge if anyone was in the building. He damaged the building badly. He shot the camera up. That behavior legitimately instills fears in my client. It is not rational behavior. It is not within the bounds of normal social behavior. And that's their home. So what the court is proposing is in order to give Mr. Archer the full benefit and of not testifying and holding on to the property, the Fishers need to live in fear because they don't know if Mr. Archer is going to get another weapon, if he's going to choose to use it, when he would do such, what circumstances would provoke that, because this isn't normal, regular behavior. And that's the idea of a 24-hour notice. The legislature has kind of stepped in on these cases and said, out of all cases, these cases need to be handled quickly. Now, if you state a regular civil matter, can take, depending on the presiding court, just under a year to up to a couple of years, and they can get permission to go longer. In this case, we have a criminal matter that could be pending for a week, 9 months, a year. Mr. Archer has shown that he is a prolific litigator, and in this matter, with me, he has threatened to file an appeal. So there's no reason not to believe that perhaps he wouldn't file an appeal in the criminal matter. In which case, then, I can tell you the Court of Appeals docket runs about 18 months. Maybe faster on criminal, but the civil certainly runs that, 18 to 20 months. That's a long time to have him sit in the property. I believe Mr. Archer got a fee waiver, which shows that he doesn't have funds. So now he'll be sitting in the landlord's property at $1,200 a month for however many months we're going to go forward on. And that debt is just debt that my client will lose. It's just a burden that he has to bear because Mr. Archer chose to shoot out a camera and a building. I think if we weigh the legislative command that these are fast actions and that in certain circumstances they're even faster, that weighs to not carrying this case. And if we look at the burden placed on an innocent party, and I know that Mr. Archer is presumed to be innocent under the law, but Mr. Fisher isn't even facing charges. And so for an innocent party who will have to now live in fear in their own home and lose income, and in addition to that, these parties don't get along. There's been, and correct me if I'm wrong, but 5 restraining orders filed between Mr. Archer filed 3. 2 of them were denied at the initial hearing. 1 was granted and not upheld. Ms. Crow has now filed 1 which was granted and served today, and there'll be a hearing on that one. It's a mess. And if we're looking at kind of the judicial mess and the back and forth, no one is served by taking this case and pushing it out forward. And I get that the court is sensitive to that. But at some level, I think it's Mr. Archer's burden here. He has chosen to try to retain his possession, and he's defending, and that's fine. He can defend in his criminal action. but it shouldn't carry this case. This case should go forward. He can invoke the Fifth, and we can agree on a system and get the least impact possible. But honestly, we're not looking for his testimony. There's a video of him shooting the camera out. And I have a witness who will testify that he's admitted to doing it. And then the question comes down to is whether or not there's substantial damage. And I understand that Mr. Archer will argue that, well, I could get up and deny it if I weren't facing the criminal case, or I could get up and try to say something. But retaliation, he can testify that the landlord gave the notice due to retaliation. That's not going to be implicated in his criminal matter. I think it's a huge burden to ask this party to just carry forward, and it's certainly a huge burden if Mr. Archer is deciding to just hold on to the property. If we want to talk about dark patterns, it's not dark patterns. It's just a legal strategy that I've observed in the prior FED and actually both of them. Mr. Archer's prolific litigator. He buried me in motions. Some of them AI generated with fake sites, but buried me in motions. The idea is to get a settlement from a burdened party. It's just legal extortion, and that's not what protecting his Fifth Amendment right is about, to enable that pattern. It just would be wrong. So we would ask the court, we're willing to work with the court to protect him so that the jury won't draw inferences. We've offered to waive the jury so that the court can do it, and then Mr. Archer can be assured that the court will understand what the law is and not draw negative inferences. We're willing to work with him, but setting this over indefinitely for the pendency of the criminal matter is the worst solution as far as equitable solutions between an innocent party and one who has done something. You have the camera right here.
Mr. Archer.
There's certainly been a pattern of things being said that are omitting very substantial parts of the current situation. I have a no contact order. I'm not even able to go to that property to grab 3 minutes worth of my things that I've built my entire life around. Indeed, certainly the real-time tracking camera that is alleged to have been shot was itself illegal. And in the police report provided to me by the district attorney, plaintiff told the police officers that a judge had given them the okay to have this camera. And that's not true. Maybe it was misheard by the police officer, but the idea that we are trying to scam the plaintiff is outrageous to us. We moved there in good faith, and we tried to communicate in good faith up to way past like where there was probably any hope, but we're not after money either. There was a previous settlement offered to us of like $4,000, and then later a different settlement of $2,000 was offered to us. And
let's focus on why why you need to have your Fifth Amendment right protected.
So it would be difficult to really state why, because anything I say can be used against me in a thing with very, very serious consequences that is very fraught. I had an email. I wasn't prepared for today because we thought that he would be resetting today. I planned on being much more prepared. for all of these interactions, but he stated in, I think it was his answer to my answer, his reply to answer pleading, he stated that the exact same, I'm sorry.
Anything to add, Mr. Ainsworth?
I have no objection to the court looking at what was requested in the previous case. I don't know what was requested in the previous case. I haven't looked at it. Whatever the court feels from that description that Mr. Archer needs, then the court can grant. Obviously, I will acquiesce to what the court needs to do.
Okay. So the request was appointment of counsel, which I can't grant. The alternative requests are real-time transcription. I do not believe that's an option, but I'll leave it to Ms. Chavez. Written orders, it all depends on what kind of rulings I'm making. An extended time for oral responses and responsive filings. In terms of oral responses, I can give you more time, but once the trial starts, filings are already kind of locked in. There's not more time to give. So we can definitely give you time if trial is going to start to do what you need to do to organize yourself, and I don't think that's a problem. I think I just wanted to make sure that there were requests that you're making that I'm aware of, so then we can be more mindful about how to accommodate you.
Thank you.
Okay, so let's take a break for about 10 minutes until at least 10:45. I'm going to review some materials, and then I'll make my decisions. And primarily it's going to be based, we've discussed the motion to disqualify already, so it's going to be the motion to reset and the motion to abate or continue based on the Fifth Amendment right. I do not believe the motion for accommodations, because I'm denying the request for counsel, needs to be addressed, but that's where I'm going to focus my time in the next 10 minutes.
Thank you.
All rise. We are back on the record.
We're back on the record in the matter of Fisher versus Crow and Archer. Case number is 25LT25667. We took a break for the court to review some information as well as to prepare for its ruling on the two pending issues. I understand the parties may have some other requests.
Judge, we might be, I'm not certain if we have an agreement. I will put on the record what I think maybe, have we agreed or?
I mean, yeah, I do understand it. As far as it pertains to Ashley, obviously there's a little question, but I mean, we're certainly a lot closer than we were.
Okay, but so as pertains, so theoretically what we've agreed on is that the parties would be, there would be a stipulated agreement with Mr. Archer. Ms. Crow is not here. There would be a default entered. We would agree to set aside that default if Mr. Archer carries through with his part of the deal, and there's no non-compliance. The stipulated agreement would be that he agrees to, he's off the property. He can return for a 3-week period between the hours of 8 a.m. and 5 p.m. to remove his belongings. That 3 weeks would begin when we can have the no contact in the pre-trial release order modified to allow such a thing. We would be really pleased if this court could do that, but I haven't the vaguest idea.
I would love to be able to do that for the parties. Usually the other party in the criminal case is the state, and they usually want to be heard. And they usually will stipulate, but I can't make that ruling because they're an actual party to that case, and they will require notice to say whether they have a position.
Okay.
I mean, typically I've seen it happen where they will sign off on if Mr. Fisher agrees to that, but I think that they have a right to have notice at least and be heard on it. Okay. So I cannot today say that yes, that is something this court can do.
Okay, we kind of thought that. So we would then structure the agreement so that the 3 weeks begins when we get the court to modify it, and it won't start today.
Okay.
So that's the proposal that I think we have.
Just the confusion over Ashley's time being restricted as well.
Ashley would be able to return on the same,
Because she's not barred from the residence at this time.
but if there's a judgment of restitution, she would be.
Because what Mr. Ainsworth is saying is because she's not here, a default will be entered, and at least with respect to Ms. Crow would be removed from the property or technically not able to remain on the property, subject to any allowances by Mr.
So
Fisher.
a default judgment would be entered against her because she didn't attend?
Correct. Because today's the day of trial, and we haven't had a ruling on whether she should have missed trial or not.
Okay, interesting. Yeah, I mean, just if it has any bearing, it was, like I said, stated on the record in this action and the previous one. You know, she said very clearly the only day that she cannot attend is December 10th. You know, she's like supposed to be there for her grandma. So I would hope that goes some distance for asking for leniency on the default judgment against her. But I don't know. Maybe that is pretty cut and dry.
Do you want to be heard on that, Mr. Ainsworth?
Sure. So we need to have the whole case resolved, and if we don't have the whole case resolved, none of it's resolved. So the default judgment resolves it in a manner that then we are able, and we're promising, and on the record, that as long as you either get all your stuff out in that 3-week period, or when you don't have your stuff out, then it's gone.
That's
you don't
nice
come
to
back.
me, but I can't speak for her.
She would have to get her stuff out also.
Mm-hmm.
And if it doesn't happen, then the default would stand. And quite frankly, if you try to come back after that, you would also have a judgment against you.
It makes sense.
So it's an enforceable promise. But the promise is, as long as you guys are out in 3 weeks from when the DA agrees, or the court modifies that order, then no one will have a judgment against them because we will set it aside.
I
And the
understand.
case will then be dismissed in that manner.
I do understand. And so the basis for this would be that Ashley's not here. A default judgment will be entered against her regardless. Is that?
That's the request. And it sounds like the settlement proposal.
So not to give you legal advice, if you were to prevail in your case, there would be no judgment against Ashley, whether she's here or not. But if you were to lose today, absolutely there would be a straight judgment, not a default judgment.
Right.
There would just judgment after trial against
understand that very well.
both of you. So we're just wrapping it up. If you had been able to get Ashley on the phone, she could agree to this, and it would all be a stipulated agreement because she could communicate assent to the court. You are not a lawyer.
Right.
And you're not an agent of hers for purposes of
And I didn't know
coming
we
to an
could have
agreement.
different judgments, like since I'm here and she's not.
It isn't different judgments, but we could do it with the same judgment, but you're not going to be happy with that.
Right.
I mean, I could say we get a judgment against both of you, and then we agree to
I
set it aside.
had also seen other people appear and a party of the defendant not be present, and that was fine at the time because I think the other person was sick or something, but.
First appearance gets sloppy, and they allow things that aren't strictly according to the rules.
Right.
In this case, because it's a binding promise, if you can get her on the phone, then fine. But if not, we'll do what we can do here.
I mean, eventually I can get her on the phone for sure.
Not eventually.
Well, that's what I can speak to.
Okay, but So either we have a deal
We
or
need to figure out what we're gonna do with this case, because I have jurors waiting downstairs. So if we're gonna proceed, we're gonna proceed. If we're not, then I need to put the settlement on the record, or the terms on the record, and then I can release the jurors.
Yeah.
Yes.
It sounds good to me. The only thing I was uncertain about was, her going from not being restricted to having a time restriction, insofar as that plays into my original estimate on how much time it would take us to move. I wasn't sure why that provision was added.
I mean, I don't want to speak for Mr. Fisher or Mr. Ainsworth, but couldn't you still have the default and not have the time restriction on Ms. Crow? You still have the default in essence. I don't know what the property and what access she requires for the property, but then at least that's not the holdup that Mr.
That's fine.
Archer is worried about.
We can keep, Ms. Crow can continue to have access.
Okay, so why don't we put the terms on the record? I'll make sure that Mr. Archer understands the terms, and then I'll ask Mr. Ainsworth to draft the actual document.
Okay, and then we would probably, because of just the nature of these claims, we would want to put on, without the jury, because we're the ones who requested the jury, we would waive jury and put on a prima facie as to Ms. Crow. It should only take 4 minutes, and that would allow the default to be secure.
Okay. Okay, does that make sense? So what we're going to do is we're going to put the settlement on the record. Mm-hmm. Then they're going to waive a jury and proceed what's called by way of a prima facie case against Ms. Crow, which means they're presenting what they would have presented in front of a jury by way of testimony to this court to see if the elements are satisfied where they can have a default against Ms. Crow. Then they have something that's enforceable against Ms. Crow, and the settlement is enforceable against you, and then I can release the jurors.
Mm-hmm. And that's today?
That's right now.
And that's just unfortunate, because it seems to me like she, tried in good faith to, respond to his need to reset for today. Can I argue on her behalf? Is that necessary, or?
Well, the other option is,
I'd hate to see her.
Is if we leave this matter open, but then but then the matter open just for her doesn't resolve anything for Mr. Fisher, and then it just unwinds the whole process.
Right, and it would just basically go back to that continuance kind of a thing. Right. So I have a decent idea of what's happening. I guess if you could do that, but I would just ask that we preserve everything for the record as it pertains to Ashley, and maybe me making a decision that affects her super negatively or something. I just want to make sure everything is kept tight in that way.
Sure. Okay, so I'll ask Mr. Ainsworth to put his the settlement on the record, and then whatever evidence you need for the prima facie. Please.
So the parties agree as follows, that Mr. Archer that the tenancy is terminated, or Mr. Archer agrees that the tenancy is terminated, that he will be allowed to return to the property for 3 weeks to remove his belongings. He'll be allowed between the hours of 8 a.m. and 5 p.m. That 3 weeks will start when the no contact order in the criminal matter is modified to allow that. Mr. Fisher is agreeing to petition the DA's office for that to happen. We will proceed today to put on a prima facie case against Ms. Crow in the event that a judgment of restitution, and that would be before the court, and in the event that a judgment of restitution is granted, we would agree, Mr. Fisher agrees, to set aside that judgment so long as Mr. Archer carries through on having his things removed and not coming back to the property after that 3-week period has ended. And that dismissal or the set aside on the judgment would be without costs or fees.
And then that would also include, do you want to put in the provision what you are intending for Ms. Crow's access?
And Ms. Crow's access will remain uninterrupted between now and the end of the 3-week period.
Okay. Mr. Archer, do you understand the terms which were just relayed by Mr. Ainsworth?
You didn't talk to him that. You didn't get me a number on the car.
I believe so, yes.
$3,500
Oh. And so the prima facie case he will now make against.
Correct.
Okay. Yep, that's fine.
Okay, so I will ask Mr. Ainsworth to draft that settlement in terms of, or that order with respect to Mr. Archer. In terms of Ms. Crow, then Mr. Ainsworth, if you want to put it in front
And
of me.
I have with me a Multnomah County form that I can modify. It's in triplicate.
Okay.
And it's an FED agreement form. And so I thought we might be able to do that and have it signed and
Sure. I don't mind, yeah.
get it all wrapped up.
Sure. But why don't we do the prima facie with respect to Ms. Crow?
Okay.
We've done the settlement on the record for Mr. Archer. Then I'll go down and release the jurors while you draft up that document. I'll come back and review the document.
Okay.
So whenever you're ready for the prima facie on Ms. Crow.
I would call Terry Fisher.
Okay. Mr. Fisher? Fisher, I don't mind if we don't need to put you up there. I'm going to have you stand to be sworn.
Please
And then,
raise your right hand.
go ahead.
Under penalty of perjury, do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Then please take a seat and state your name for the record.
Terry Fisher.
Go ahead, counsel.
Okay, Mr. Fisher, do you own 44515 Southeast Highway 26?
Yes, I do.
That contains units 2.
Yes.
Okay. And on November 6th of 2025, well, I'm going to hand you Exhibit 1, which is a notice of termination. Was that served on Ms. Crow?
Yes, it was in the lobby downstairs here.
Okay, and did you observe that yourself?
Yes, I did.
Somebody handed it to her?
Yes.
Okay. I'm going to show you what's marked as Exhibit 6. Is that a copy of the rental agreement in this matter?
Yes, it is.
Okay. And I'm going to show you Exhibit 2. Is Exhibit 2 a copy of the, what is Exhibit 2 a photograph of?
It's a photograph of the bullet holes in the side of the building that was destroyed by shooting.
And I'm going to show you copies of exhibits 3A, 3 and 3A. Are those copies of estimates for the cost of repair?
These are copies of estimates of repair for that metal in the camera.
And I would move entry of 1, 2, 3, 6.
Exhibits 1, 2, 3A, and 6 are admitted.
Okay. And did you have, you had a video camera at the property, is that correct?
Yes.
And did it take a video?
Yes, I did.
And did it show a video of Mr. Archer? Did it show a video of Mr. Archer in relation to the shooting?
Yes, I did.
Okay, and what did you see?
I saw Mr. Archer go from his car underneath some tarps, and a few minutes went by, and then you could see him between the tarp and the building, pointing a gun at the camera and squeezing off several rounds.
Thank you.
And did those, did you bring the camera with you? Mark this as,
Just make up a number.
this is exhibit 12. Is this the camera?
Yes, it is.
And you can see the bullet holes going into it?
Going into it and where they came out the other side.
Okay, so they pierced this
Through
plastic
and through,
part.
yes.
And they pierced your building?
Yes, one bullet went through 4 or 5 ribs on the building, of metal ribs.
What is the building made of?
Metal. It's metal siding on it.
Okay, and just to be clear here, is the building located in Clackamas County?
Yes, it is.
Okay, and the parties have had put in their pleadings that they're still in possession, but as far as you're aware, are they still holding possession of the premises?
Yes.
Okay. Okay, entry of exhibit 12.
Exhibit 12 is admitted.
Did she take the exhibits? Did you collect those?
Yeah, you're welcome. Have a seat.
Very, very efficient. I didn't know. It's not nice to do to an old man. In your opinion, is the conduct of shooting out the camera and shooting into the building, is that conduct that would justify an eviction within 24 hours?
I definitely do. I'm afraid to be around the property.
Okay. We would rest with that.
Okay. I find that the court finds that the plaintiff has made a prima facie case against defendant Crow. Service was made based on the 24 hours. Defendant Crow is not present. They are still in possession. There was a reasonable basis for the eviction notice. And so the defendant Crow will be found in default.
Okay. And then, Judge, I'm going to write this up, and then we'll have something signed, but I think we're okay at this point.
Okay. Any questions, Mr. Archer?
I didn't hear proof of service in there anywhere.
It was exhibit number 1. It was.
I don't have a copy. Oh, I do. Sorry.
It was the notice of termination, and Mr. Fisher said that he saw them being served in the lobby downstairs.
Yeah, I do see it. I was just curious. The date is November 4th on the termination notice.
Correct. But he said he saw the actual service on November 6th.
Okay.
Is the testimony.
Fair enough.
Okay. Okay, so I will step off, go excuse the jurors, And then I'll just let the clerk know when we're ready. Hopefully it's before noon. So then I can review the order and then sign it and have it entered. Okay?
Thank you. In gravamen of this is the substantial issue in the criminal proceeding. I do believe my next criminal hearing is next week. As a person embroiled in that thing, I could say I am very interested in solving that quickly. I am not interested in living at the plaintiff's premises. My girlfriend, Ashley, who isn't here, but who really is attending her grandmother's surgery, she has a torn meniscus right now. And so in that reply to answer, just like Mr. Fisher has stated in the past that I have lots of friends and family who should be willing to help me, Mr. Ainsworth stated in his reply, just send Ashley to get your things. But partially my disabling condition is one that means that I really do substantially better looking at my stuff and like, oh, I should grab that, It's not quite so analytically compartmentalized that I can just send another person. And indeed, when we sent a person there to try to help remove things, the police were called and they were marched out at gunpoint after I was banned from the property. But substantially, to kind of take a stance against many of the kind of visceral things that were said about why this deserves to be, the strictest, most quick thing, and my fundamental rights shouldn't matter because of how socially degenerate the alleged behavior is. I think it's very, very, very clear these are the same alleged acts. And further, the Clackamas County Code Enforcement is going to be, what they say, they're going to make him apply for a permit, but they suspect he will definitely not be approved. This was found out before the alleged incident when we were in the middle of our last eviction case. So there's no staying there. And certainly nothing at issue here would do anything to resolve the very clear statute that rent is to be paid. That's even outside of contract law. My understanding, we pay rent to live there, even though I'm not able to live there. At this point, I'm kind of in this to try to get my stuff back. We need to move out, and that's not possible. We've tried to negotiate and find a solution. Would perhaps be happy to, examine a hard cap on a timing thing, if that would be, he says that this could go on for a very long time. But that's not in my interest at all. But I fear that, I very much believe that I am not guilty of a crime. And I really don't want to be in a position where I am just saying something in a way that makes that a harder hill for me to climb, And I think it's very possible. It seems to me like with the other thing, what other circumstance could give a rise to a more conflicting thing? This is literally the same exact thing, which I do think is probably fairly rare for landlord-tenant cases. Perhaps not outrageous in the extreme allegations, but just to put the cherry on that, from my perspective, the plaintiff does not live in our house. It's his shop where he keeps his cars. When he had restraining orders against, we had restraining orders against him, he was able to live at his house. Now, all of a sudden, with the criminal allegations, he is purporting it to be his business, which has led to me being issued a no contact order for my home, because he's certainly, from our perspective, he's changing how he's talking about it, and that's why we can't move out, which is crazy to me. But if we go forward and, this is denied, and we lose the eviction case, I mean, I could maybe get a little bit of help to save, just a smattering of our stuff, but, it'll be absolutely devastating. And that's, coming from a place that I haven't been home in a month. Things are already kind of all in the open, or, all not set, but we would love to come up with a very speedy solution. I don't see any solution that lets me do the majority of our move out, which is generally what happens, unless we can get rid of the no contact order, and that can only be done through the criminal proceeding. They've offered a plea deal to me that we may well take. That literally just hinges on whether there's a civil compromise possible, which is relevant to this case. I haven't heard back on that, but, and again, starting to ramble a bit, logically, it's absolutely a huge thing. Like, I don't know what other questions could be asked of me, like, that wouldn't lend to my criminal prosecution being affected. And also the differences in standards is worrying. If a finding is made in this case based upon the preponderance of evidence, and that is used, for example, against me, where the bar is supposed to be much higher, it's complicated. I'm already a bit at odds with the situation, but yes, perhaps could there be a hard limit, or obviously the other thing is the rent thing was brought up very, very recently. This was like two days ago. Rent was issued for the first time in the reply to my answer. They could absolutely, if they had grounds to litigate, they could take us to court on failure to pay rent and get rid of us immediately, or get a rent check. That's how that works. Like, the issue is that they're kind of just saying that in order to, like, make the continuance thing an issue, for example. I don't know how much that speaks to the request to stay pending the criminal matter for the constitutional right.
My problem with the stay is I have to weigh it against what Mr. Ainsworth is requesting, your rights against what Mr. Ainsworth is requesting. I'm looking at the criminal case. It looks like it's set for trial next week, but your attorney just withdrew this week or last week, and so it's very unlikely you're going to get another attorney and and be up to speed on a criminal case when the trial is set for the 17th.
I thought that the case management hearing was on the 17th.
Correct, but that's, so even then, the case manager, unless you resolve the case on case management, most likely you're going to get a trial date in January or February.
Yeah, we have all the discovery. I do believe that January 17th date you might be referring to was the initial
It's the February 17th is, I'm sorry, December 17th is the original jury trial date.
The speedy trial demanded date, right? Like, it would have had to have been by that date.
I don't know. I just know that that's the original date, and now that there is a hearing for your attorney to withdraw on that day, and then most likely a case manager on the 18th.
Yeah.
So
we do have a plea deal.
So let me speak, please. So the problem is there is no end in sight in terms of the criminal case, because we don't have, like, it's not set for a plea. If you said it's set for a plea, I would see that, and that would help the court kind of narrow the scope and know that at least the criminal case, there's going to be resolution, so we can bump this out, and we know how far we need to bump this out. It's case manager can be, your next attorney may say, I need more time to get up to speed, and then we're bumping the case out 2 months. And so that's the problem.
I know it looks like really bad to be, getting rid of a public defender. I just really thought I could benefit.
I'm not going to get it. It's your right, and it's not a problem. It's just
he's just very fresh.
It's your right, and it's not a problem for you to ask for a new public defender. I'm just saying that if you're saying there's a cap, I don't see a cap that would help resolve some of the issues raised by Mr. Fisher. Having said that, I still have to weigh it against your right to your Fifth Amendment rights. Okay. So I'm going to just pen my decision on that, or just hold on that. The last motion, I believe, I need to hear is the reasonable accommodation. So what?
And Judge, if I may, the fact that he's offering a cap says something about how absolute the right is. That he himself is saying, well, maybe we can just cap it no matter what happens in the criminal case. Thus, he's agreeing to a situation where possibly this case goes, he has the same dilemma, and the criminal case continues. It kind of shows how serious the assertion of the right is.
I understand. Before we go to the final one, my understanding is this is a straight eviction, correct?
Yes.
Couldn't the issue be resolved if the defendants are allowed on to move off the property and terminate the lease agreement?
Certainly.
And that would kind of, because that's what you're asking for, is the removal of the property anyway.
Yes.
And so okay. I wasn't sure if that was it, if I'm missing anything. Okay, so final motion that I will hear argument on, and then I'll take a break to decide on these motions. Your request for accommodation based on your medical condition and your need for counsel. So there's not a right to counsel in a landlord-tenant. So what other accommodations are you asking for?
So I had requested judicial notice be taken of the previous landlord-tenant proceeding. I didn't know if that would allow the filings in that case to be seen, but basically this motion was filed kind of before the motion for a stay pending the criminal proceedings. I was thinking basically that such an accommodation being asked for, even though it's probably not done at all, that it could provide the sort of protection I would need in order to do both
But what accommodation? Even Mr. Ainsworth said you haven't established enough to actually qualify. But I'm assuming, I'm just going to, for the sake of the argument, say that you need accommodations. What are you asking from this court? I can't give you counsel.
Of course, yeah, and I understand. So I, and in the past I'm used to like a participatory process where it's like possible to figure out what is actually actionable that could help. But, generally time to collect my thoughts insofar as like, making sure that I have my documents about me there. There have been times where I appeared remotely in the past. I don't know if that would really be that feasible in something like this.
I wouldn't allow it in a trial, no.
But like this, having stuff spread out here, like had this been set for a date that was like, actually possible, with this kind of a system and lots of preparation and good faith conferring, like it's been good that we've like conferred on exhibits a bit. That didn't happen with the previous attorney. There was none of that complying with the SLR. So realistically, to come up with what accommodations I would try to ask for. Even that is something that's a little better for me to like kind of write and approximate and I guess ramble a bit about what is helpful in regard to that. But as far as what I think would be possible and actionable and equitable for my opportunity to participate, like I'd be interested. I spoke with Lisa Chavez about real-time captioning. That's a service that I believe is currently offered. She mentioned that might be possible. I have to look into it a bit more. The fact that even Fed proceedings are so much faster than everything else makes this hard to do pro se. And so kind of knowing what accommodations would really be helpful to me, the most concise thing I could say now is what I filed in the previous case, insofar as it explained that the judge seemed to understand, or at least, kind of seemed to get an idea about the disability and seemingly kind of accommodate it. That would be obviously closer, I think, to a reality that could exist than asking for counsel, which again, that was an idea that I had that could solve the problem in my mind, but rather than the stay to avoid, incriminating myself. I do understand that that's a weird thing to ask for. And generally the accommodations that I think I need are not outlandish like that.
And so that's what I'm trying to figure out is what specifically are you asking for?
Right. So I probably have and also I have lots of documentation about my disability and
I'm not questioning your I'm just asking what your accommodations are to see if it's something I need an additional assistance on, or whether we just take more time in front of the jury, or what you're asking for.
Certainly that would be very helpful, I think. And I don't know, I mean, obviously you mentioned earlier, if we were to continue today, we would be doing some kind of procedural talks about how everything is handled. And indeed that happened in the previous one as well. We ended up having a 45-minute hearing just going over jury selection and these things. Mr. Fisher was pro se at that time too, so it was, kind of helpful to go through that. And I know I'm not going to ask for any actual procedural differences, but this has felt very helpful, the way you're kind of trying to zero in on the information and even a little reminder, hey, are you saying everything you want to say? And I do think I could, given 10 or 15 minutes, I could really kind of write it down. Part of the accommodation is just a little bit of removal from the pressure of being on the spot, and I could do really good work. And I don't need AI to do the work, but I feel like I can kind of approximate what I'm trying to say fairly well in this manner. But if I kind of put my nose to the grindstone and write it out, and again, if you do have the ability to see the one that was filed in the previous case, I don't know if the motion to have judicial notice taken enables that, but that was my understanding of what it accomplished.
I'll wait to hear from counsel. I mean,
Fair enough.
It's not a problem for me to review other cases, so I don't think that's an unreasonable request. But I don't know if there's certain things that you're asking for specifically from other that I can actually do.
Yeah. I had been working with Lisa Chavez, the ADA coordinator, as recently as a few days ago. And in our conversations, we were kind of talking about what was possible. But, I apologize. I feel like defining it super concisely is kind of specifically something that I very much struggle with. It's a bit of a rough kind of thing, a thing that's rough around the edges that is hard to really say in specificity.